And we're getting inside of our feature, The Legal Landscape, any second now. We've been telling you the topic will be understanding confidentiality agreements. And this, by the way, is going to be the final episode in season 1 of The Legal Landscape. Companies and businesses and business people, actually, regularly deal with sensitive information that they do not want falling into the wrong hands. Whether it is a secret business plan, maybe a new proposal, or private business deals, the parties may wish to keep it confidential. But the question is, how do you do that? Well, our guest this morning is a notable senior partner and senior attorney in the commercial department at DunnCox, and he will help us understand confidentiality agreements and how they may help with keeping sensitive information private. We're joined at this time by Jerome Lee. Good morning, Mr. Lee.
Hi, Richie. How are you doing?
I'm doing well. Thank you for joining us. This represents our final episode in season 1. I can tell you it has been really a great addition to our program here in the morning, and we thank you all for the inputs that we've had over the period of the last 12 or so weeks. Thank you.
You're welcome.
Okay, now let's get right to it. What is a confidentiality agreement, Mr. Lee?
Well, it's a legally binding contract that prohibits someone from sharing confidential information while keeping it safe. It is also sometimes referred to as a non-disclosure agreement, an NDA, or a secrecy agreement, and it should be in writing.
Should be in writing.
Yes.
Who would you say are parties to these agreements?
Well, at least 2 or more people, and they can be both companies and individual persons. The first person to the agreement is known as the giver of the information or the disclosure. And the second party to the agreement is known as the receiver of the information or the recipient.
Can there be a situation where the disclosure is also the recipient?
Yes, where the information flow is 2 ways. Each party will both be the giver and the receiver of the information, which each receiving the other party's information and sharing his or her or its own information. This is what is sometimes known as a mutual confidentiality agreement.
Okay. When are confidentiality agreements used, generally speaking?
Well, as you said earlier, they are used when a party or a person wishes to prevent, without approval, the sharing of confidential information. Such information would include where the parties are, say, employer and employees, or where the parties, 2 of them, are exploring or negotiating a proposed business deal, or an inventor is protecting his invention or discovery, for example, a secret formula or a recipe or a computer software program. And finally, in another situation would be where business partners among themselves protect trade secrets. And, of course, the information that is shared should only be used for the purpose for which it was provided.
Oh, got you. By the way, to our listeners, we'd like to remind you, if you have a question on this subject, understanding confidentiality agreements, you can send us a WhatsApp message as quickly as you can to 876-383-1166. If time allows, we'll ask Mr. Lee to address it. My next question for you, though, Mr. Lee, what type of information is usually covered in confidential agreements?
Well, any information which is of value and which the discloser wants to preserve from public disclosure, even while he's sharing it with the recipient. In other words, proprietary or sensitive information. For example, secret formulas, manufacturing processes, work which has a commercial value, your private information, findings from your research, your accounting information for your business, your future plans, your strategic proposals, and any other information you consider to be of value. And it can be in the form of written documents, booklets, magnetic tapes, diskettes, thumb drives, electronic form of storage, and photographs.
Okay. So is it a case where disclosure of such information is not permitted at all?
Well, you should not disclose confidential information, but in certain circumstances, you're allowed to do so. Very limited, though. For example, if you knew about the information before you received it from the disclosure, if it was publicly available through no fault of your own, if somebody provided to you who did not breach any obligations of confidentiality, if you, for example, went and developed it on your own and arrived at the same conclusion, and of course, in obedience to a court order.
Okay. A message coming in here. What happens if there's a breach by the recipient?
Okay. The recipient faces the threat of being sued and could be required to pay financial damages and costs to the giver of the information. Where the agreement allows, the giver can also apply to the court for an injunction for any threatened or actual breach of the agreement.
We're speaking here with Jerome Lee. He's a senior attorney at DunnCox Attorneys at Law, and we're looking at understanding confidentiality agreements. A very, very important subject, and I'm learning quite a lot from you this morning, Mr. Lee. How long is the agreement, and what happens after the agreement?
Well, the agreement is usually for a fixed period. Could be, say, 6 months, 12 months, 2 years, or any other agreed time that the parties agree. At the termination of the agreement, it usually provides for the return of the confidential information to the disclosure, where it is in tangible form, or the destruction by the recipient, where it is stored in electronic or digital form.
All right. Thank you for that. Well, we've gotten a lot from you this morning. I personally have learned a lot, and we thank you. Before you go, though, it is customary that our attorneys share with us a did you know tidbit before departing. Do you have one such this morning?
Well, I have a three-word one.
Okay.
It's keep secrets secret.
Keep secrets secret.
That's right.
All right. I like that. Hashtag keep secrets secret. Okay. Thank you so very much, Jerome Lee. We really appreciate it. And we thank you and the rest of your team for, all that you have given us and shared with us over the past several weeks. Thank you. We're looking forward to season 2. Until that time, you take good care.
Take care.
All the best. All right. Thank you once again, ladies and gentlemen, and for listening. And a big thank you to Jerome Lee, senior attorney and senior partner at DunnCox Attorneys at Law. As I said earlier, this is the final episode in this season of The Legal Landscape. And again, we say a big thank you to DunnCox Attorneys at Law for sharing some sound legal advice to our listeners over the past 12 weeks or so. And we, like yourselves, look forward to season 2. Time now 8 minutes after the hour of 8 o'clock. This is Top of the Morning. You're on the edge. 105 FM. We inform, we educate, and we entertain. We're here to get you up, to get you dressed, get you fed, and out to work, school, or play. Keep it locked. What you want is what you get, and what you get is more than you bargained for.